All right, by my clock, it is now 4:30 in the afternoon. Ms. Connor, do you have any reason to believe we should not proceed at this moment?
No, the necessary parties are present. Thank you.
All right, thank you. So good afternoon. I am Judge Eric Price, and I'm the presiding officer for this case. And Ms. Bremner, I noticed on Zoom you are not muted. I guess I'd ask that you'd mute yourself unless you're going to speak.
Oh, thank you. I only responded about recording, and that's my.
Perfect. Thank you. So we are here today for the entry of the panel decision in the Commission on Judicial Conduct case number 11005-F-204, in re the Honorable Tracy Flood, Judge of Bremerton Municipal Court. Decisions that follow contested hearings are required by Commission rules to be filed in an open public meeting of the Commission. As this unanimous decision is lengthy and reading will take considerable time, multiple members of the hearing panel will read portions of the decision. And because of the decision's length, each reader will omit citations, footnotes, and attachments. The full decision, without omissions, will be posted on the Commission's website later this evening. Following the reading of the decision, we will not be taking questions, but Judge Flood or her counsel will have an opportunity, but not the obligation, to provide a comment. Again, this is an option, not a requirement. We will now begin with the reading of the decision. So before the Commission on Judicial Conduct of the State of Washington, in re the matter of the Honorable Tracy S. Flood, Judge of the Bremerton Municipal Court, CJC number 11005-F-204, the Commission decision and order. The order begins with a quote from the Code of Judicial Conduct Preamble, Part 2. Judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. That it should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. Part 1, Introduction. This matter came before a panel of the Commission on Judicial Conduct for a hearing on October 21st, 2024, based on the Commission on Judicial Conduct's statement of charges alleging that Judge Tracy Flood, respondent, violated Canon 1, Rules 1.1 and 1.2, and Canon 2, Rules 2.5a and 2.58 of the Code of Judicial Conduct. Participating in the hearing were the presiding officer, Judge Eric Price, Court of Appeals Judge Member, Ryan Archer, Attorney Member, Terry Ashby Scott, Public Member, Wanda Briggs, Public Member, Judge Michael Evans, Superior Court Judge Member, Judge Christian Hedin, District Court Judge Member, Tara Miller, Public Member, Marcia Moody, Public Member, and Gerald Schley, Public Member. Attorney Reagan Rasnick served as disciplinary counsel, and attorneys Ann Bremner and Nick Gross were counsel for respondent at the time of the hearing. From July 2023 to May 2024, Attorney Vonda Sargent represented respondent. For some of that time, Attorney Steve Fury also represented respondent from October 2023 to May 2024. Respondent's current attorneys, Ann Bremner and Ted Buck, entered notices of appearance on behalf of respondent in July 2024, and Nick Gross filed an appearance in October of 2024. Part 2, Charges. The Commission found probable cause to support a statement of charges which was served on respondent on July 12, 2023. The respondent was charged with violating. And now I will quote from the 2023 Statement of Charges. Canon 1, Rules 1.1 and 1.2, and Canon 2, Rules 2.5a and 2.5b of the Code of Judicial Conduct, by failing to treat court staff and attorneys appearing before her with patience, dignity, and respect, and treating court staff in a demeaning and condescending manner. Respondents' mistreatment of attorneys and staff resulted in their departure from the court. As of this writing, at least a dozen staff members have resigned their positions. Most recently, the court administrator who resigned effective June 9th, 2023. Those who have left employment at the court include every staff member who was employed at the court when respondent took the bench in January of 2022, and at least 4 who were hired by respondent. Numerous attorneys have ceased to practice in Bremerton Municipal Court. Each of these individuals cite respondent's treatment of them as the sole or contributing factor to their departure. Respondent's inability to retain staff has negatively affected the functioning of the court, resulting in such failures that include hearings not being properly set, cases not being timely docketed, alleged victims of domestic violence not being able to access the court to request filing no contact orders, and probationers not being monitored. The next section is Part 3, Pre-Hearing Procedural History. Judge Michael Evans will now begin reading. Judge Evans.
The Commission has been admonished to address ongoing code violations as promptly as possible to minimize harm to the court and to the public. In this case, multiple actions on the part of respondent resulted in delay of the process for more than 2 years, from the time she was initially put on notice of the Commission's concerns with the statement of allegations in November 2022 to the third and final scheduled hearing date of October 2024. The confidential initial proceedings portion of the proceedings was extended based on the Commission's need to investigate respondents' concerning allegation of racism in her amended response to the statement of allegations contained in the probable cause documents that are part of the record in this case. The initial proceedings portion of the case was also extended as respondent availed herself of coaching at the urging of Commission staff, hoping to ameliorate the situation at the courthouse. Further delays at the instigation of respondent are described below. Upon service of the public statement of charges, respondent was advised of Commission on Judicial Conduct Rules of Procedure, CJCRP 20A, which sets a deadline of 21 days for a judge to respond to a statement of charges, and which also provides that failure to answer the charges, quote, shall be deemed an admission of those charges, and the Commission will proceed to determining the appropriate sanction, end quote. Respondent's response to the statement of charges consisted of a one-line general denial, quote, Judge Flood denies all allegations against her, end quote, and was received on August 14, 2023, 12 days after the August 2, 2023 deadline. Disciplinary counsel moved to strike the denial and deem the charges admitted pursuant to CJCRP 20A. After briefing in which respondent's counsel accused Commission staff and counsel of bad faith, the hearing panel deliberated and denied the motion to strike the general denial and deem the charges admitted. The order denying the motion acknowledged respondent's answer was late, but held that there's a strong preference to resolving Commission cases on the merits, cautioning counsel to comply with the Commission's rules of procedure, CJCRP, going forward. Unfortunately, that was not sufficient to ensure compliance with either subsequent scheduling orders or specific directives to cooperate with opposing counsel. 22 pre-hearing motions were filed in this case prior to the fact-finding hearing. Most of the pre-hearing motions filed in this case by both parties were based on respondents' defiance of routine litigant obligations. The early briefing, motions, and non-compliance with scheduling and discovery orders on the part of respondents' original counsel manifested unusual and elaborate disrespect for the presiding officer and the Commission's process, to the extent that it is fair to attribute acts of respondents' first set of counsel to respondent. The defenses they presented were unusual in their overt disrespect for the Commission's process, membership, and personnel. Both in writing and in a hearing, respondents' first counsel articulated the likelihood that the presiding officer's rulings would, quote, again be rubber stamping anything Commission counsel requests, end quote. In multiple motions and briefs, respondents' first set of counsel accused disciplinary counsel and Commission staff of unethical conduct and the Commission itself of acting unconstitutionally and intentionally unfairly. and referred to, quote, Judge Flood's well-founded belief that a decision has already been made and this hearing is a sham. Nothing more than a railroad with a foregone conclusion before we start, end quote. Notwithstanding criticism to the contrary, the presiding officer made rulings in which each side prevailed in whole or in part, depending on the merits of the issue. In addition, respondent filed an extraordinary writ of prohibition to the state Supreme Court, asking the court to order the commission to end its proceedings on a variety of grounds without reaching the merits of the case. The hearing was originally set for December 4th, 2023. This date was first continued by stipulation of the parties and reset for March 18, 2024. On March 5, 2024, while the parties and the commission were preparing for the rescheduled fact-finding hearing, respondents' first set of counsel orally represented to the presiding officer in the gravest terms that respondent's physical health was so compromised and vulnerable that she could not comply with the schedule set out for the parties. These mostly unsubstantiated but extremely dire claims required twice resetting the time for hearing from its second set date of March 18, 2024 to the week of October 21, 2024. The presiding officer had an obligation to balance the sensitive and personal representations of respondents' health crises with the ongoing nature of the charges against her and the need to address the well-being of the court staff and the public. Respondent was ordered to provide some form of proof of the medical crises she was experiencing. The presiding officer was scrupulous to grant reasonable requests to seal personal medical documents, and after conducting a bone club analysis, to seal motion hearings where respondents' right to privacy outweighed the public's right to be privy to a public hearing. She either did not comply with these reporting requirements or did so in a cursory and incomplete fashion. Having raised the issue of her own health to obtain a lengthy extension of the hearing date, respondent vigorously resisted providing the required substantiating medical information, even though permitted to produce it under seal. When it was clear the respondent's health provider, the Department of Veterans Affairs Puget Sound Healthcare System, the VA, would not comply with the commission's subpoena under federal health privacy laws, respondent could have provided the ordered confirmation of her health status by waiving her confidentiality for the limited purpose of providing it under seal, but she chose not to do that, which raises serious questions about the credibility of her representations that her medical situation kept her from participating in the commission's scheduled proceeding. Throughout that time, respondent remained on the bench despite the medical issues, with the harm alleged in the statement of charges filed on July 12, 2023, potentially ongoing. These motions, associated briefing, and attendant multiple orders are part of the record in this case. Illustrative of the scope of this conduct on the part of respondent and her original counsel are orders issued February 12, 2024, May 2, 2024, July 31, 2024, and August 26, 2024.
Section 4, hearing testimony and other evidence. On the morning of the first day of the hearing, Monday, October 21, 2024, the parties proffered a joint stipulation of facts and code violations and agreed to proceed to a hearing as to the appropriate sanction. Among other things, the parties stipulated that respondent violated Canon 1, Rules 1.1 and 1.2, and Canon 2, Rule 2.8b of the Code of Judicial Conduct. The stipulation was silent as to the remaining charged rule violation, Rule 2.5a, and the stipulation did not ask the panel to dismiss that charge. The stipulation set forth agreed facts and further provided that up to 6 written witness declarations could also be considered as evidence by the panel, and each party could present the testimony of up to 5 live witnesses with the addition of the respondent should she choose to testify in her case in chief. The panel agreed to accept the stipulation as reflected in many of the findings of fact below. where live testimony or other evidence was inconsistent with stipulated facts, the panel assessed all available evidence to arrive at its findings after the conclusion of the hearing. The hearing was recessed until Wednesday morning so that the parties could create and exchange their respective declarations and submit objections thereto. Disciplinary counsel agreed that she would not recommend the sanction of censure with removal. Further, both parties agreed that respondents should be ordered to complete training approved in advance by the Commission. Section 5, Findings of Fact. The findings of fact in the stipulation are accepted except as contradicted by or expanded upon below, based upon testimony and other evidence presented at the hearing. Respondent is the first Black woman Bremerton Municipal Court judge elected in November 2021 and serving since January 2022. At that time, the court was fully staffed with a court administrator, assistant court administrator, senior legal technician, 3 legal technicians, and a probation officer, most of whom were longtime employees of the court. Respondent succeeded a white male judge who had been in the position for 21 years until his retirement. Respondent retained the staff she inherited and invited them to her swearing-in ceremony. She was aware of only 2 staff members who attended and took that as a slight by the others. However, at the hearing, staff members testified that 6 court workers attended, and those who were absent were unable to attend because of their work schedules. The staff members respondent presumed absent had attended the standing room only ceremony from the overflow room with the ceremony broadcast on monitors. Complaints regarding respondents' treatment of the court staff and attorneys began to be received by the Commission in July 2022. By February of 2023, all the original staff members had left the court, in part or entirely because of respondents' conduct toward them and general mismanagement. The replacement staff members hired under respondents' authority were less experienced by the time of the hearing. All of them had left the court, and by the time of the hearing, all of them had left the court, except for new administrator Christina Rauenhorst, who was herself looking for different work at the time of the hearing. The court staff, who were called to testify by disciplinary counsel, whether in person or through declarations, testified that respondent was abrupt with them, confusing, inconsistent, demeaning, and made them question whether it was even possible to satisfy respondents' inconsistent and sometimes legally incorrect directives. The result was a chaotic, dysfunctional court run by an inexperienced and demoralized staff that failed the public in multiple significant respects. These staff members included women and people of color. By September 29, 2023, all but one of the first set of replacement staff left the court. Although respondent signed a stipulation that said she accepted responsibility for being, quote, impatient, disrespectful, and discourteous to staff and attorneys, end quote, that these actions, quote, showed poor judgment, end quote, and that, quote, multiple staff left the employment of Bremerton Municipal Court because of her changes and communication, end quote. Her testimony and defense abundantly demonstrated that she does not actually accept responsibility for her actions or the consequences to the court and the public. See below for examples. Respondent caused the complete turnover of 2 entire sets of court staff, but for one individual seeking alternative employment at the time of the hearing, with attendant catastrophic loss of expertise and experience. The consequent failures of the Bremerton Municipal Court under respondent's tenure are significant and injurious to the competent operation of the court, which is a judge's fundamental responsibility. These failures include mismanagement of court funds. On multiple occasions, the safe at the court was left open with the funds inside, and there was no clerk present who knew how to close the accounts out for the day. Receipting for funds received was far overdue. People posting bond would not be reimbursed those funds even after the defendant's obligations to appear had been satisfied. In at least one instant, respondent ordered court staff to accept funds from a defendant at the counter when his account had already gone to collection, despite a binding legal contract with the collection agency requiring the defendant to satisfy their obligation with collections, rather than the court, once payment in arrears were referred to collections. This not only embarrassed the overworked court employee, but required her to take extra time to undo the court's contract violation ordered by respondent. Docket entries were routinely not kept up to date and were sometimes 3 to 4 weeks late. Stakeholders could not rely on the court record to know case status. Hearings were mislabeled. Law enforcement was not timely or accurately informed of court actions, such as ordering or lifting the requirement for an ignition interlock device and mandatory license suspension or revocation, issuance and rescission of warrants, and no contact orders. Longtime personnel were stripped of duties without arrangements for their duties to be fulfilled otherwise. Probation officer Ian Cohen, who had served in that position for 22.5 years, was forbidden by respondent to notify the prosecution of alleged probation violations and was required to send them to respondent instead. Mr. Cohen, who has training and certification in mental health counseling and who had been awarded statewide recognition as Probation Officer of the Year in both 2008 and 2016, was no longer permitted by respondent to prepare documents for Western State Hospital to provide necessary information for the time-sensitive completion of competency and sanity evaluations. Consequently, multiple competency orders were not timely fulfilled, including Henry Daniels, whose competency restoration was ordered, but that order was not conveyed to Western State, so he languished in custody for almost a month with no action. Similarly, respondent took over from the court administrator, reviewing staff requests for leave or permission to work remotely, but did not assure that there was coverage for the people who were granted leave, which resulted in crucial positions being left vacant on a haphazard basis. Bench warrants that were recalled were not processed in a timely fashion. In addition, bench warrants ordered were not processed and sent to police. In one example, a defendant, Albert Glover, came to the court and had a warrant quashed. The court did not get that information to police, so he was wrongly arrested on the quashed warrant. Stop sticks were placed behind his car during the arrest to prevent him from fleeing, and his tires were damaged when an officer moved his car. He also had to pay a bondsman for the wrongful arrest to avoid being jailed that day. Defendant Nicholas Braden's life may have been saved by being taken into custody on a warrant that languished without processing for months. Instead, he was released from a hold in another jurisdiction as the Bremerton warrant was not in the system, and he died of an overdose within days of his release. Multiple no-contact orders were not processed, nor was the rescission of some no-contact orders, which either stripped victims of the court's protection or subjected defendants to wrongful arrest. These failures required extra time on the part of the prosecutor's office to institute the practice of emailing law enforcement to safeguard against the potentially deadly consequences. Many times, crime victims would not receive a certified copy of no-contact orders granted on their behalf. Restitution payments received by the court were frequently not timely dispersed. Crime victims went for as long as 5 months without receiving the restitution that had been paid into the court by defendants. I'll now pass the reading to Commissioner Marsha Moody.
Offers to train or assist respondent. The confidential initial proceeding stage of this case was extended after respondent alleged the complaints against her were the product of racism against her as a Black woman, so that the commission could focus on investigating the merits of that allegation. During the confidential stage of the proceeding, prior to and again after the urging of commission staff, respondent engaged in coaching and training with an expert of her own choosing. Early on, problems began to manifest. Respondent reached out for help to many people who came to her assistance, including Latricia Kinlow, a highly experienced and well-respected African-American district court administrator with 26 years of court experience. Ms. Kinlow is active in multiple national and state professional organizations for court managers, facilitates and participates in training for court administrators and judges, as well as the Center for Court Innovation in New York. Ms. Kinlow participates with the District and Municipal Court Managers Court Helping Courts Committee. Because of her reputation with that committee, respondent requested Ms. Kinlow's assistance and support telling Ms. Kinlow some of the problems respondent was experiencing were due to her race, though she did not specify to Ms. Kinlow or to the panel during the course of this entire proceeding specifically who she believed targeted her because of her race. Ms. Kinlow testified she was concerned by this, being herself a Black woman, aware that the geographic area of Bremerton is not very diverse. Ms. Kinlow reached out to another municipal court administrator with decades of experience, Jennifer Johnson, who self-identified during the hearing as African American and Mexicana, with whom Ms. Kinlow had a close working relationship, and recruited her assistance to try to help respondent and her court. Both women personally visited respondent's court to do an assessment of the situation and see how they could help. Ms. Kinlow stated as she prepared to assist, she anticipated they would find, quote, macroaggressions, microaggressions, anything that supported what Judge Flood believed she was dealing with at the court at the time, end quote. She testified what they in fact found were multiple administrative duties that were in disarray and had fallen far behind, such as collections, receipting of parking payments, and improper use of the O-Court system, the electronic document system that allows parties and court authorities to promptly view, sign, and otherwise manage court documents. She said they were short-staffed, and of the staff, many of them were new to any court and did not know what needed to be done. Those new staffers had been there under 6 months, doing the best they could. Over a period of 4 months, Ms. Kinlow returned repeatedly in person to the court, as did Ms. Johnson. In addition, Ms. Kinlow recruited other courts to allow their staff to provide remote assistance and do virtual clerking for hearings and similar tasks. The court was without a court administrator, and essential court functions were not being performed, such as the daily close of business accounting of funds received and the monthly accounting of the receipts from specific individuals in specific cases, and the appointment of those funds to the city, county, or other entities required by law to receive a portion of those funds. Though assistance from courts helping courts is typically short-term, Bremerton Municipal Court required the program's help from September of 2022 to May of the following year. Ms. Kinlow testified about one occasion when she was present and witnessed the judge harshly yelling at one of the new staff members, Amber, who was at the front desk reducing Amber to tears. Ms. Kinlow testified that she comforted Amber, who was sobbing from respondent's treatment of her. Ms. Kinlow testified that when she told respondent later that they could not afford to lose more staff, that Amber was working as hard as she could, but said the judge's response was, quote, she did not yell at anybody, end quote. Ms. Kinlow further testified respondent did not accept any of her suggestions and gave the specific example of establishing a cutoff time with prosecutors for placing matters on the court jail calendar so the clerks could properly prepare those files for the hearings. Such coordination is necessary because the jail personnel have to bring the prisoners to the court or have them available to attend court remotely, and the judge must have the relevant files ready to conduct the hearings in a meaningful manner. Significantly, when reminded of her testimony that she was alert to any instances of macro or microaggressions or things associated with institutional racism or workplace racism, Ms. Kinlow testified, quote, I did not witness anything like that, end quote. Ms. Kinlow testified she met with Stephen DeRosier, the first therapeutic court coordinator in Bremerton. Part of his job was setting up the systems and processes for the therapeutic court, and he showed Ms. Kinlow an intake form he had designed that greatly impressed her. She said he should show it to respondent because it was, quote, amazing, end quote. Ms. Kinlow was present when he tried to share the document with respondent, but when he tried to share it, respondent held up her hand to stop him and said, quote, I told you, email me stuff. Don't tell me stuff, email me, end quote. Ms. Kinlow testified Mr. DeRosier replied, quote, yes, ma'am, end quote, slumped and walked away. Ms. Kinlow also testified that she attended a staff meeting at respondent's invitation and was struck that respondent did all the talking, and that when staff attempted to ask questions or give input, they were usually cut off by respondent in dismissive fashion and not heard. Ms. Kinlow noted respondent was particularly dismissive to Ian Cohen, the probation officer who was trying to ask questions. Respondent told Ms. Kinlow afterward that respondent felt the meeting, quote, went fine, end quote. Before a new court administrator was hired, Ms. Kinlow testified she was present to assist in Bremerton almost every other day. For a length of time, Ms. Kinlow received permission from her presiding judge to loan Bremerton 2 clerks to assist respondent's court. Those clerks were made uncomfortable by respondent's demeanor in court towards attorneys and asked permission to no longer assist. That permission was granted. Though Ms. Kinlow's ongoing efforts to assist Bremerton's court, and at the time a new court administrator, Christina Rowenhorst, was hired, Ms. Kinlow became aware around the spring of 2024 that court hearings were being mislabeled. In at least one instance, respondents specifically ordered a case that was in pretrial status to be set for an arraignment, which is an earlier preliminary hearing at which time-sensitive matters different from a pretrial hearing must be addressed. Ms. Kinlow testified that she became aware respondent planned to attend the National Judicial College out of state during the time Ms. Kinlow and others were helping the court through its troubles. She advised respondent not to leave for the discretionary training because the court was in crisis, but respondent opted to attend nonetheless. The panel found Ms. Kinlow's testimony highly credible in part because of her personal and professional background and because of the very evident neutrality with which she approached the problems at the court. Witness Maurice Baker testified by sworn declaration. Mr. Baker is a retired, highly qualified, and experienced court administrator who volunteered to get the court back on track for months, working unpaid for 8 or 9 hours daily. During his time with the court, he scrutinized the court operations and each position closely to find what the deficiencies were and how they could be addressed. Despite literally having greeted him with open arms and tears of relief, respondent ultimately rejected his suggestions and he ended his time with the court. He concluded in his letter of resignation to respondent that, quote, the court's current level of functioning is as good as it will get under your chain of command, end quote. Although Mr. Baker's testimony was given by written declaration, his background, motivation, and experience are such that the panel found his testimony highly credible. The misconduct that is the subject of this proceeding continued unabated after all efforts at assistance. I will now pass to Judge Christian Houdin, one of our commissioners.
Ill treatment of court staff and attorneys. Oral testimony and written declarations that were admitted into evidence showed that multiple court staff were reduced to anxiety, tears, panic attacks, and other manifestations of stress and trauma, and were made to feel fearful, frustrated, and powerless, as many of respondents' actions and inactions were detrimental to the court, causing confusion and delay at best, and risking injury and expense to individuals, as well as liability to the city. Unlike some other judges whom the commission has sanctioned for failing to treat court staff and attorneys with courtesy, dignity, and respect, respondents' violations were less overt in that she did not use foul language, usually did not raise her voice, and did not specifically call people names. Rather, she consistently condescended to, undermined, and confused both staff and attorneys. She would overtalk anyone else present in a meeting, refuse to listen to input, decline to give written instructions, and thereafter deny the oral instructions she had given, and when she cut off other speakers, would often do so with a dismissive hand gesture and or vocalization. Former staff member Ian Cohen testified respondents' treatment toward him was demeaning, belittling, treating me as though I was a child, treating me as though I had no clue what I was doing after doing the job for 22 years. Mr. Cohen testified at length about the manner in which he felt invalidated by respondent, and that his distress was so evident that multiple people checked on him. Quote, coworkers, defendants, police officers, attorneys, defendants that didn't like me, end quote. He testified to the impact on his physical and mental/emotional health, that he lost sleep and experienced depression and anxiety as he absorbed the loss of a job he said he had loved. Quote, everything I had worked for 20 years, end quote. He described the impact upon him as worse than the death of a close family member, and described an occasion his wife found him crying on the floor of their garage. He described that he searched and was able to find another job with the city, although out of his field. The panel found Mr. Cohen's testimony highly credible. In addition to the substance of his testimony and his recognized professionalism in his field, his demeanor while testifying was sincere, more sorrowful than telegraphing any agenda, and therefore highly persuasive. Respondent would mock and scold staff members, sometimes for questioning or sometimes even for complying with her own orders. She expected staff to start hours before court opened and to be available for electronic communications from her after hours and on weekends. She would not take any responsibility for her poor choices, lack of clarity, or unwillingness to listen. Multiple staffers reported being made to feel inadequate and as though there is nothing they could possibly do to please respondent or at least avoid her displeasure. Witnesses testified that respondent would cut off or ignore their advice, that her changes to established court procedure were not just different, but sometimes contrary to law, and that when they did try to comply with respondent's changes to court processes, respondent would often deny directing the change. At least 5 attorneys refused to practice in her court because of its inefficiency and the way respondent treated them, including, quote, persistent interruptions, eye rolls, glares, condescension, end quote. For example, see the declarations of Serena Daigle, Stephen DeRozier, Don Williams, Jacob Murphy, and Maurice Baker, attachments F, G, H, and I. The panel observed that the witnesses testifying for disciplinary counsel, particularly former court staff, were solemn, stressed, and sad, at times coming to tears or near tears. Similarly, they testified that either they or other court staff under respondent were frequently despondent and cried during the workday. Although respondent highlighted her compassion for defendants in therapeutic court and for defendants in general, she is notably lacking in compassion for some of her own court staff who complained of her treatment of them, including those who shared with her that they were living with disabilities, like Serena Daigle. Ian Cohen disclosed he suffers from dyslexia, yet she consistently chided him for minor spelling and punctuation errors. Serena Daigle testified by declaration. She originally worked with the Bremerton Municipal Court through the Courts Helping Courts program. She had 17 years experience at the time in courts of limited jurisdiction and took a pay cut to join and assist the Bremerton Court. Ms. Daigle disclosed to respondent that she has a disability stemming from a traumatic brain injury and that she would sometimes need to ask clarifying questions. Rather than acknowledge and accommodate that, Ms. Daigle's sworn declaration notes she would see respondent respond to Ms. Daigle's questions for clarification of respondent's rulings by clenching her jaw, apparently holding back anger and stepping away from the bench. Later that same day, snapping at Ms. Daigle that if she did not know she was expected to fill out respondent's court orders, that she should ask, though she had manifested anger at Ms. Daigle earlier for asking questions. In Ms. Daigle's declaration and attachment, she details the humiliation and stress she experienced from respondent to the point that Ms. Daigle was considering self-harm and left the court to preserve her well-being. Dawn Williams' declaration and exhibits describe her optimism and willingness to work with respondent when she first took office. Ms. Williams was the court administrator at Bremerton since 2011 and had 27 years of experience in various courts. In her declaration, Ms. Williams noted the judge made changes without explaining the purpose, to the point, quote, "It began to seem she wanted to make change just for the sake of exerting her authority rather than for a reason she could explain," end quote. Ms. Williams described how respondent would not clarify her instructions and, quote, "would not take responsibility for having made a mistake or given me unclear instruction," end quote. And that when Ms. Williams tried to give input on a problem, respondent's proposed change might cause, respondent, quote, "would shut me down. I would characterize the way she acted toward me as condescending, belittling, and bullying. She used a mocking, scolding tone of voice as though talking to a child. By the end of February 2022, I felt like I could not do anything right in Judge Flood's eyes. I cried in the car on the way home from work," end quote. Ms. Williams left the court in May 2022, taking an alternative job with a large pay cut and forfeiting 930 hours of sick leave. Many of the staff who left Bremerton Court because of the stressful and debilitating environment created by respondent testified they had loved their jobs before respondent's tenure, and some who had worked there for decades accepted lower pay and/or conditions simply to get away from the atmosphere and conditions respondent created. Bremerton Municipal Court has a small staff, ranging between 7 and 9 employees during the time in question. In all, 19 employees and volunteers left the Bremerton Municipal Court during respondent's tenure, in part or in whole because of her conduct. This number does not include the clerks from other courts who had assisted through Courts Helping Courts who were allowed to stop assisting because of their concerns about respondent. Witnesses on behalf of the respondent. Testimony favorable to the respondent, in addition to her own, came from 3 live witnesses called at the hearing by her counsel. Kiera Galden is a Black woman who introduced herself at the hearing as a full-time student seeking her PhD in clinical psychology, who recently gave birth to her first child. Ms. Galden testified she knew respondent first through community organizations and that she had been invited by the then Bremerton Municipal Court Administrator, Jennifer Johnson, to help with the therapeutic court, and then with a community outreach effort she called a Youth and Law Forum. Ms. Galden joined the therapeutic court and was there for about 6 months, 2 years prior to the hearing. The therapeutic court was created by respondent, and court was held weekly on Tuesday mornings. Ms. Galden worked about 15 to 20 hours a week. Ms. Galden's impression of the judge was that she was both professional and kind, and that other court staff gossiped about respondent behind her back, quote, rolled their eyes, end quote, at her words and actions, and, quote, pushed back, end quote, against respondent's efforts to make the court operate smoothly. Ms. Galden has limited knowledge of the actual chain of authority in the court, which unequivocally places the judge at the top. Ms. Galden testified in answer to questions that the court administrator, not the judge, was, quote, in charge, end quote, of the courthouse and the court staff. She was unaware of who, if anyone, the court administrator answered to. She acknowledged only having had exposure to the half-day-a-week therapeutic court and was not familiar with the rest of the court's operations. She characterized the commission's investigation and prosecution as, quote, ridiculous, end quote. Therapeutic court coordinator Famous Tyra has an associate's degree as a paralegal and has worked previously in court-adjacent work, such as being a parole officer for the Department of Corrections in Georgia, and in some capacity associated with public defense in the state of Oregon. He self-described as Black. He had been disillusioned with the demeaning and oppressive conditions in prisons and in the corrections systems where he worked. He was hired by Respondent in September of 2023. He was interviewed for the Bremerton court position by Respondent alone and was excited and inspired as Respondent described her vision of reforming the court system into a rehabilitative and empowering institution. Part of his testimony recounted his surprise that he was not met upon arrival on his first day by the court administrator, nor by any other co-worker, and that there was not an onboarding process in place for him, and he basically had to find his own way. This lack of preparation is explained by reference to the declaration of Maurice Baker. Mr. Baker's sworn declaration outlines how Respondent chose to replace Mr. Cohen without coordinating with anyone else in the process or decision, giving the Human Resources Department about 1 day's notice of the hire. In Mr. Tyra's position with Bremerton Court, he is present in therapeutic court for its court sessions that take place on Tuesday mornings, assists the new probation officer as needed, helps therapeutic court participants find treatment and housing, and conducts outreach on behalf of the therapeutic court, such as assisting with the court's thrice annual resource fairs. Mr. Tyra testified his experience with Respondent was that she was supportive, patient, and helped him to achieve a higher level of job satisfaction than he previously had achieved. Mr. Tyra had the impression that the probation officer and other court staffers disliked Respondent and hoped she would be, quote, out of here, end quote. He testified he had never seen Respondent yell at anyone or even speak with them inappropriately. He testified that the other staffers' criticisms of Respondent were so incessant and inconsistent with his own experience that he took to eating lunch in his office rather than in the lunchroom to avoid them. Mr. Tyra testified that he felt the impact of racism at the court himself, that he had to, quote, walk on eggshells, end quote, and had the impression that 2 other former employees had also. Mr. Tyra testified he observed 2 prosecutors and various clerks in therapeutic court who treated Respondent disrespectfully. William Cohn works 19 hours a week as the security officer for the Bremerton Court, having started there in August of 2023. He is African American. He testified he perceives Respondent's interactions with people to be very professional, patient, and courteous. The commonality between Respondent's live witnesses is that they had limited background or knowledge in the practical operation of a court and were not required to perform in ways that affected the daily workings of the regular court. These witnesses all had limited exposure to the judge and limited opportunity to observe the general operation of the court. Excuse me. Mr. Tyra and Ms. Galden were deeply inspired by respondents' generally stated goals of reforming the criminal justice system. Their testimony all supported respondents' allegation that she was ill-treated by others at the court and not accorded the respect that she was due, impliedly because of her minority status. Testimony that some staff disliked respondent is not inconsistent with testimony that respondent treated some staff poorly. Each of respondent's live witnesses, noted above, presented as entirely sincere, but their limited exposure to the relevant issues did not give the panel reason to give much weight to their testimony regarding the charges. 2 court staffers hired by respondent testified by declaration. Jennifer Riley is a legal technician 2 who was trained in part by Maurice Baker. She feels respondent treats court staff fairly, although Ms. Riley did note that respondent, quote, sometimes says things that others might perceive as rude, but I do not believe she intends that, end quote. Ms. Riley recalled an incident where a respondent interrupted Ms. Riley during a therapeutic court staff meeting, and respondent thereafter placed Ms. Riley on administrative leave. Ms. Riley stated the court, quote, functions well for the most part, end quote, though she acknowledged not everyone, including herself, is fully trained. She declared respondent supports the functioning of the court and is blamed for some issues, like recording failures, that are not her fault. Sarah Nettleton is a legal technician for the court, hired in March 2024, who wrote a declaration on behalf of respondent. She has not worked for a court before. She declared respondent often exhibits genuine concern for the staff as a team, as well as for defendants and the public. Ms. Nettleton declared respondent is not to be blamed for mistakes made by mostly new staff, that they are understaffed, and that respondent is being blamed for, quote, some things she is not aware of, end quote. Ms. Nettleton did describe an incident early on in her tenure where respondent talked over her and later apologized. Ms. Nettleton disclosed that she is living with multiple sclerosis and that the judge has been very accommodating and is a good judge. Leslie Weber is a former co-worker of respondent at the U.S. Department of Labor, who was a union representative. In that capacity, she declared she would have been aware had respondent been the subject of complaints and that she did not hear of any. Ms. Weber declared respondent had been very nice, friendly, organized fun activities, did a good job, and was neither unprofessional nor reported as rude when they worked together. Sarah Dreyfus is the co-founder and principal at Revolution Lab, which consults with companies regarding workplace culture, organizational structure, governance, evaluation, and strategic planning. Ms. Dreyfus has worked for over 20 years in public health and related fields, and a primary focus for their master's in public health was on race and racism's impact on health disparities. Ms. Dreyfus' declaration on behalf of respondent, see attachment L, described a, quote, race-forward, end quote, model of racism existing on multiple levels: internalized, interpersonal, institutional, and structural, and their opinion that, quote, it is reasonable to question, end quote, whether the charges against respondent are in fact, quote, implicit biases and attempts to tone police Judge Flood as her accusers encounter their own discomfort around her positionality as a judge, end quote. At this time, Commissioner Tara Miller will resume or proceed with the reading.
Respondent testified as to her life story, background, and approach to work. She testified about her background in the military, her role in supporting family members, and her education, recognitions and honors, and other credentials. She testified her goal in seeking the position of Bremerton Municipal Court was to make change, end quote. And her background in the military, parentheses, Bremerton has a high military population, end parentheses, and the existence of a 0.1% local tax to address mental health and substance abuse was auspicious for her start, the city's first therapeutic court. She testified about the grant she applied for and received for the therapeutic court, which operates for a half day once a week. Regarding her own conduct, respondent testified she'd never, as a judge, yelled at anyone in the courthouse. She testified that so long as she agreed with others, quote, things are perfect, end quote. But, quote, as soon as I say not, I disagree, I'm then told I can't do things. That's not how it's done. Straight out of the blanket. You can't do that, end quote. Her perspective was that the conflict she experienced with staff and attorneys was because she chose to try different approaches from the way that things had been done. And I understand that historically things may have been done a particular way, but when you ask the question why you have historically done it in this way so that I can understand why it's being done this way, and the response is no answer, it's the sense of just because. Okay, so my thoughts and practices is, okay, let's try it. Let's do it a different way. It doesn't hurt anything if we try it in a different way. If it doesn't work, we'll try it a different way. But the system, the criminal justice system, is broken. I didn't break it. The criminal justice system has been inherently broken for a while. Respondent testified in regard to disciplinary counsel's witnesses that it is in my opinion that the things that are being said by everyone is their personal impression of me because they didn't like me and they do not like me. Some people came in, I believe, with motivations other than to help, end quote. She testified regarding the time frame in which Ms. Kinlow told her it was unwise to leave the court amid its crisis. Quote, there was never enough time that passed between fires to allow for there to be an opportunity to truly address any issues. When original court administrator Dawn left, I was not present for the final 2 weeks as it was the month of July during my anniversary. So we had plans to travel to Atlantic City, and in the month of November is also an annual CLE conference that I attend. End quote. Regarding her ongoing communication issues with staff and the city attorney, respondent referred to the interactions with them as, quote, pushback, end quote. And she said she experienced the same from the entire city council. In regard to her own treatment of staff, she denied ever belittling Ian Cohen or speaking to him in a condescending tone. In regards to the vocalization Mr. Cohen testified to in the hearing, as he described how respondent would silence him, she gave her interpretation of his testimony. And to say that I made some type of eking sound, am I being called, and that's racist in tone, am I being called a monkey by your implication that I'm making some sound or I'm looking in some way? Respondent testified that she was unable to control how other people reacted to her and did not connect his crying and her presence to her treatment of him, testifying that she had no idea why Mr. Cohen came to tears or got emotional upon interacting with her at the courthouse. Her perspective was that people who were critical of her were all white, with the exception of Jennifer Johnson, and their motivation was entirely or in part racist. She denied ever using a rude or condescending tone with any defendant, lawyer, probation officer, court clerk, employee, or member of public during her entire tenure of the court. She testified to feeling beset and isolated. By way of impeachment, disciplinary counsel questioned respondent about her tenure as president of the board of a nonprofit organization, Kitsap Community Resources. Respondent was showed a letter wherein the staff members of that organization complained to the board that the respondent had created a hostile work environment through her bullying and intimidation tactics, including cutting off staff mid-sentence during presentations and discussions, lack of communication, signaling out staff members for unprofessional and degrading discussion, and violating bylaws. The panel did not rely on this document as substantive evidence regarding respondents' conduct at the community organization, but did rely on it to assess respondents' credibility when denying outright that she had ever treated court staff and the attorneys in a degrading or belittling fashion. The hearing panel found the respondent's demeanor while listening to other witnesses' testimony and her own demeanor significant in its assessment in this case, particularly her lack of apparent reaction or smiling when witnesses cried or came close to tears when testifying about her treatment of them. When asked by disciplinary counsel, question, do you remember seeing Mr. Cohen break into tears a couple of times while he was testifying? Answer, I saw him wiping his face. Question, you sort of smiled a little bit. Why did you smile when I asked you about Mr. Cohen breaking into tears? Answer, because your description is breaking into tears. I saw him wiping his face. So there's a difference of your opinion is that he broke into tears. My opinion is that I saw him wiping his face. I wasn't watching his every move. The panel found respondents' combatively evasive and sometimes condescending replies to disciplinary counsel questions helpful in assessing the testimony. For example, when you quote, you have admitted that you verbally admonished your staff for not following instructions. Is that right? Respondent answered, quote, I have admitted to what's in the stipulation, end quote. And, quote, I believe there's language in the stipulation. If you want to refer to that, you should bring it up, end quote. Respondent gave the same or similar response, parentheses, e.g., I believe the document speaks for itself, end of parentheses, to multiple questions. Under questioning, respondent specifically stated that she disagreed with multiple facts agreed to in the stipulation. A panel member asked respondent if she changed her demeanor towards staff since she was first apprised of the commission's concerns with a statement of allegations during the confidential portion of the proceedings. Respondent answered that she actively sought out training, brought in a speaker regarding stress and protein and being healthy and eating and how that stress can be in the workplace, end quote. And she testified that she brought in a conflicts trainer as well as attending a change management course. Parentheses, there are, in addition to the personal coach respondent engaged referred to above, end of parentheses. And I'll refer to Commissioner Ashby Scott.
The role of institutionalized and specific racism in this case. Respondent has consistently and voraciously asserted that the complaints against her and the commission proceedings are premised almost exclusively in institutional and overt racism against her as the first Black woman judge in a predominantly white community, where she succeeded a popular white male judge in a one-judge court. She further alleged the complaints stemmed from a small group of detractors who disliked her personally because of her demographic and because of her demographic identity. There is no rational basis to deny the toxic and pervasive role that racism has historically played and continues to play in the American justice system, and the state of Washington and the city of Bremerton are no exceptions to this reality. The commission panel members for this hearing include Black, biracial, and Native American members, and all the members acknowledge the existence of both targeted and systemic racism in our culture, and acknowledge that it is inevitable that as a Black woman, respondent experiences racism and sexism. It is also true that respondent bears the responsibility as part of the great power that she holds as a judge of conducting herself in a fashion that ensures the greatest possible public confidence in her independence, impartiality, integrity, and competence. And in these regards, she has failed. The reality of racism neither explains nor excuses the failings found here. Despite concerns over the allegations of significant ongoing harm, the Commission extended the investigative phase of this case upon receiving respondents' supplemental response to the confidential statement of allegations to focus on her allegation that the complaints were based on racism. The Commission independent investigation did not substantiate her contention. Latricia Kinlow and Jennifer Johnson, highly experienced and competent Black women court administrators, first engaged with the respondent in her court as part of Courts Helping Courts, ready to identify and address her contention that the court's problems stemmed from racism. But that is not what they found. Institutional racism does not cause a judge to belittle, demean, and drive away 2 full sets of court staff, notwithstanding the assistance of multiple highly qualified volunteers and multiple types of training and coaching. Many of the staffers who complained about respondents' conduct were unacquainted with each other and interacted with respondent at different time periods. The specific instances of racism presented and argued by respondent are few. They include an allegation that one former employee persisted in using her first name rather than addressing respondent as, quote, judge, unquote. This was undoubtedly annoying and quite possibly disrespectful, though not an uncommon experience for women judges and other professional women. Her interpretation that Mr. Cohen's testimonial description of her shushing him as though he were a small child as, quote, racist in tone, unquote, end quote, is not reasonable in context. He was testifying to her dismissive and belittling manner of addressing him, not the reverse. The actual power differential in that relationship was that Mr. Cohen was submissive, vastly overpowered, and ultimately forced by the respondent's action to abandon his beloved life's work. Some of the respondent's witnesses testified generally that she was sometimes treated with disrespect by some attorneys or staff, but specific incidents were not described, nor was there any testimony that this treatment was universal nor even typical. Historical and current racism in the judicial system in Washington state and throughout the country are real and constitute a betrayal of all that the Constitution and the judiciary should protect. There was not sufficient evidence in this case to substantiate respondents' defense that her conduct and the accusations against her were a product of racism. Commissioner Evans will continue.
Section 6, Conclusions of Law. As noted above, the commission panel accepted respondent's stipulation that she violated 3 of the 4 rule violations in the commission's statement of charges, Canon 1, Rules 1.2 and 1.2, and Canon 2, Rule 2.8b. These stipulated violations are supported by the evidence and accepted as committed by the panel. The stipulation was silent as to the remaining charge violation of Rule 2.5a. Rule 2.5a, competence, diligence, and cooperation. A judge shall perform judicial and administrative duties competently and diligently. B, a judge shall cooperate with other judges and court officials in the administration of court business. Based on the foregoing findings of fact, the commission panel concludes that it has been proven by clear, cogent, and convincing evidence that Judge Flood violated Canon 2, Rule 2.5a of the Code of Judicial Conduct as charged. Respondent's failure of competence resulted in a devastating loss of personnel and a dysfunctional court, which is directly traceable to respondent's inability to manage and cooperate with others in a system in which she is the most powerful and responsible player. Section 7, Discipline. Application of CJC RP 6C Deming factors. In determining an appropriate sanction, the Commission on Judicial Conduct and the State Supreme Court must consider a non-exclusive list of aggravating and mitigating factors for a judge who has violated the code. The following factors were considered important in determining discipline. CJC RP 6C1A. The misconduct was a pattern consisting of condescending, belittling, ill treatment of multiple staff members and attorneys that drove them to leave the court. The conduct was repeated towards specific individuals and directed at multiple people over time. CJC RP 6C 1B and F. The nature, extent, and frequency of occurrence of the acts of misconduct and the nature and extent to which the acts of misconduct have been injurious to other persons. These factors are most concerning. Multiple people who worked at the court were humiliated and personally and professionally undermined in ways that impacted their physical and emotional health to the point that more than one person contemplated self-harm. People who had worked in the court system for decades and were dedicated to the work took cuts in pay and forewent benefits to which they were entitled to escape respondents' abuse. No court can operate without a competent staff consistently and promptly serving the public on a daily basis. Respondents' misconduct toward staff resulted in the loss of experienced staff who were replaced by staff who were not adequately trained or knowledgeable in the basic aspects of the court, such as the handling of the court funds, docketing, and other fundamental aspects of court operation, crucial to fulfilling its role in our democracy. The failures of the operation of the court meant that not only those with direct contact with the court, but the entire community was harmed by the failure of this iteration of the judicial branch of local government. Particularly because this is a one-judge court without other judicial officers available to ameliorate the consequences of respondents' actions, the combination of damage done to individuals and the wide-ranging harm to the operation of this court is some of the most serious addressed in the Commission's history. CJC RP 6C1C. Whether the conduct occurred in or out of the courtroom. The conduct occurred both in and out of the courtroom, but all of it at the courthouse in the context of respondents' judicial duties. CJC RP 6C1D. The misconduct occurred in the judge's official capacity, not in her private life, which is an aggravating factor. There is no indication that the judge flagrantly or intentionally violated the oath of office, so CJC RP 6C1E is not a salient consideration in this case. CJC RP 6C1F was addressed above. CJC RP 6C1G, there is no indication the judge exploited her official capacity to satisfy personal desires. She has consistently told others and testified her intention is to improve the justice system and to better serve the whole community. CJC RP 6C1H. The effect the misconduct has had upon the integrity of and respect for the judiciary is extremely negative and harmful. At a minimum, a court must operate competently, and this court has been operated by respondent with a possibly unparalleled litany of failures outlined above. A judge stands atop an extreme hierarchy of authority in the court and the community, and the damage done to the individual court workers, attorneys practicing in the court, and litigants by respondents' failures would reasonably cause anyone to lose confidence in the court's integrity and competence. The therapeutic court, which is a modest portion of the court's operation, may be accomplishing success toward respondents' stated goals of addressing the inequities and failings of the criminal justice system. However, the record in this case is silent as to how many people participated in that court and how many, if any, have successfully graduated from that program. CJCRP 6C2A, whether the judge has acknowledged or recognized that the acts occurred. Until the first day of the hearing, respondents' posture toward this case has been that it was an illegitimate and corrupt proceeding born out of unfair and racist allegations. On the first day of the hearing, she stipulated to violation of all but one of the charges, purportedly to take responsibility, but in her own testimony, she consistently denied responsibility for any aspect of her troubles at Bremerton Municipal Court. This is a serious aggravating factor. CJCRP 6C2B, whether the judge has evidenced an effort to change or modify the conduct. There was a great deal of testimony and other evidence that respondent has been offered the assistance of qualified experts, such as Ms. Kinlow, Ms. Johnson, and Mr. Baker, and that she rejected their suggestions. The evidence similarly demonstrates that she has undergone coaching, conferences, training, and other remedial measures, but that she remains certain that she is and was correct in her conduct, and that she is being unfairly maligned. CJCRP 6C2C. The respondent's comparatively short length of service in a judicial capacity could arguably be considered a mitigating factor, but that is negated by the fact that the misconduct began almost immediately upon the judge attaining her position and has continued throughout her tenure. CJCRP 6C2D. Whether there has been prior disciplinary action concerning the judge. Respondent has not previously been sanctioned, but complaints about her conduct, that is the subject of this proceeding, began almost immediately and were ongoing and multifaceted with severe consequences. This potentially mitigating element is negated because of the long-term nature and multiplicity of the violations, which began in the early part of her tenure and continued throughout. CJCRP 6C2E, whether the judge cooperated with the commission investigation and proceeding. The history of this case demonstrates that respondent consistently attempted to delay and derail the proceeding, moving to disqualify disciplinary counsel, refusing to cooperate in basic discovery obligations, including canceling a scheduled deposition of respondent 2 days before the deposition, rejecting all proffered alternate deposition dates, and refusing to answer even the most basic questions at the deposition. Respondent moved to dismiss the proceeding on multiple occasions, wrongly asserting the commission did not abide by its constitutionally mandated structure and process. The fact-finding hearing in this case was extended multiple times at the behest of respondent. The second fact-finding hearing date, set for March 18, 2024, was continued on March 7, 2024, based on respondent's representation without documentation that she had dire health issues, making it impossible for her to participate in commission proceedings. Due to the sensitive and private nature of these representations, the presiding officer granted respondents' counsel's requests that discussion of these matters take place off the record. The presiding officer ultimately required interim reports updating the status of respondents' medical issues, requiring proof that would be allowed to be sealed from public inspection, together with requiring an accounting of whether respondent was able to continue to function as a judge. In response to the order to provide status reports, respondent failed to produce documentation, offering instead vaguely worded general statements that she was undergoing evaluations. In an order granting disciplinary counsel's motion for a subpoena for the relevant records, the presiding officer noted he had entered multiple orders requiring respondent to produce documentation her counsel had promised would be forthcoming. The July 31st, 2024 order noted, quote, respondent has failed to comply with these orders on every occasion. Despite the passage of 4 months and multiple orders, nothing actually substantiating the March oral representation of these health conditions has been provided. The unfortunate and unavoidable conclusion is that respondent is intentionally not cooperating with the commission's proceeding as required under the code, end quote. Legal representatives of respondent's health provider, the Department of Veterans Affairs Puget Sound Healthcare System, declined to comply with the commission's subpoena ducis tecum, as it is not the form of court order that permits them to release medical information, but made it clear that respondent was able to sign a release of her records for the limited purpose of substantiating her representations to the commission. She declined to do so, raising questions as to the credibility of her assertions and compounding her lack of cooperation with the commission's process. There is no ethics advisory opinion that relates to this conduct, so CJCRP 6C2F is not relevant here. The factors in this case lead the panel to the imposition of a censure, with the recommendation that the state Supreme Court remove respondent from the bench. The commission panel deliberated hard and long in considering the factors available to reluctantly reach this result. The panel considered other options, including some kind of, quote, second chance, end quote. But when contemplating what kind of support or guardrails could be put in place to support respondent, it became clear that high caliber, focused supporting training measures had been offered and failed, both in terms of personal coaching and in the details of court administration. Remedial measures and guidance from experienced and motivated experts have been offered to and rejected by respondent. The panel struggled to imagine what alternative or additional steps it would take for this respondent to be a successful judicial officer. None of the panel members were persuaded that respondent truly understands the magnitude and impact of her misconduct, or even that she believes she has engaged in any misconduct at all, given her testimony. There was no persuasive evidence that she felt any remorse for her treatment of others. Therefore, there is no basis to believe that respondent has the capacity or motivation to change. The possibility of returning a judge to the bench who will likely continue in conduct that harms court staff, the operation of the court, attorneys, the city, and the public is not an acceptable outcome. And if past conduct is a predictor of future behavior, any further commission proceedings to address further misconduct would be protracted and exact an unfairly heavy toll on all involved, if indeed witnesses could be persuaded to come forward.
The final portion of the decision is the order, and it reads as follows. Based on the foregoing decision, the commission finds that Judge Flood violated Canon 1, Rules 1.1 and 1.2, and Canon 2, Rules 2.5a and 2.5b of the Code of Judicial Conduct, and for the reasons stated above, is hereby censured with a recommendation that the state Supreme Court remove her from office. Under Article 4, Section 31, Paragraph 8 of the state constitution, this sanction operates to suspend respondent from office immediately with salary from her judicial position until a final determination is made by the Supreme Court. Dated this 10th day of January, 2025, unanimously signed by all 9 members of the panel. That concludes the reading of the commission decision and order. Now there is a opportunity, but not the obligation, for either respondent Judge Flood or her attorneys to make a comment. Ms. Bremner, would you or your client like to make a comment?
No, thank you, Your Honor.
All righty. Well, that does complete this hearing, completes the presentation of this decision and order. Ms. Colliner, is there anything further before we adjourn?
Your Honor, I actually had one thing though. My understanding is, given the decision of this commission, that it will go to the Supreme Court without our appeal.
It does not require a notice of contest because there is a recommendation that the court remove.
Right. Thank you, Ms. Colliner. That's what I was
You're
inquiring
welcome.
about, and that answers my question. Thank you.
A copy of the order will be served electronically immediately.
Thank you.
Thank you.
All right, with nothing further then, Ms. Colliner, is there anything further?
That concludes the proceeding. Thanks to all who attended.
We will draw this to a close. We are adjourned. Everyone have a good